What is up, everybody? What's going on,
Hey,
Allie?
hey, everybody. Sorry I was late. I had Zoom court and the time, depending on where you are, but Central Time at 9 that ended up taking longer, and then I had something at 10:30 that I had to have somebody cover. So, sorry for the delay.
And sorry for folks who thought this was going to be Bob. Hi, I'm Jay. For folks who don't know who I am, I'm helping out here. Bob is boots on the ground in court, folks. He is there. So we are going to stream this thing as Bob is there taking notes. And I'm assuming they must have taken his phone, right? Because I was texting him. He didn't respond. What do you think, Allie?
Oh, absolutely. I just wanted to note because that is what I did. Like right before, I was like, all right, I'm gonna get, I might as well restart this computer because it keeps telling me that I need to update. And I'm thinking, I just got this thing. Why do I need to update? But I didn't want there to be an issue while we were doing this. So um, that I did that as soon as I got off Zoom, still thinking that I didn't have to be here with you till 10:30.
But we're ready to go now, folks. It doesn't start until 11. I have the screen up. It says it will be available 2 minutes before they start, and that's 11 a.m. Eastern. So that's in 10 minutes, folks. So we're not going to miss that. We're ready to go.
All right, so Bob just texted us.
Oh, he did.
Yeah, I'm trying to find this. Yeah, now I'm like, wish I didn't do that update because I can't find the little, like, put my computer on do not disturb thing that's usually right up. Here we go. Yeah, he said this is exciting, unless that was you.
No, that was him. I got it. So maybe Bob has his. Maybe he was able to take it. I mean, obviously, he must have been able to if he's texting us now. I assume he's in there waiting. So, folks, Bob's gonna be taking notes, and then he's gonna be coming out to you guys just to explain everything that we don't go over here. So thank you all so much for being here. If you could hit that like button as you come in, get this thing in the algorithm. This is a big deal, right, Ali? I mean, this is a huge
I
deal,
mean,
right?
it's a huge deal, especially if you've been covering this case, and I'm sure everyone who's joining us now has been. And it's also very interesting because it's the Supreme Court, so it's going to be a lot different than what you see in, everyday court. And Jay, for those who you don't know, amongst other things, covers a lot of court cases and what's going on the day to day. So he's got a good pulse for what you, the people who are non-lawyers, questions you might have, and plus just a lot of knowledge about what goes on in the courtroom. So, and I know what I've explained this before, but this is going to be much more formal, and you're going to have the justices all sitting at the bench, and they're going to address the the attorneys. Now, typically when you're attorneys and you're kind of learning about, all right, what happens when you go to the Supreme Court, or it's we do an appellate court sort of thing in law school, where you do a mock, you talk to, like, you're presenting a case. And sorry guys, I've been working on a lot of motions, and I'm still trying to catch up.
You're
But in
good.
any
You're good.
event, the judges are going to, so typically you're thought, like, you're going to prepare this speech and you're going to have everything ready and you're going to go in, and you got your allotted time, so you're very focused. All right, what issues do I want to start with and where am I going to go? But a lot of times, especially if the court is interested, or they've got sort of differing opinions amongst themselves, they're going to come at you like this with a question. So all the preparing that the lawyer may have done, that goes out the window. So if you see the judges asking questions, that's something you want to note, because that's telling you that's what their issue is. This is the way they look at it. And then you've sort of got to adapt on the dime and address it in the way that they have presented it. Sorry, I did do not disturb, and then I guess I did it again and undo not disturb it because Bob's messages are coming through. um,
So you don't
so
even get to. You could prepare as much as you want and think you have but you got basically you're preparing for the questions. You got to think
you
ahead
are
of time. What are they going to ask me that I got to be ready for? Because you could have a whole thing started and boom, there's a question. You got to be ready right there to go.
right,
That's scary.
and they
It's going
may
to be
come at
scary.
it. They may come, yeah, and they may come at it a different way than what you're thinking. And what's key for the lawyer to do is really pay attention to the way the judge asks it. I mean, obviously you pay attention to the question, right? But there's going to be little nuances in the way that they phrase it and the way that they throw it at you. And obviously, if it's the second question, then you've got a great opportunity to kind of maybe use a point that came from the other judge's question to tie it all together. My hope is that it's not going to be a lot of focusing on the technical stuff about the jurisdiction and what they should have done. Should they have filed certain things ahead of time? And clearly, based on the last order, that they should have. But I think with them giving extra time, as they did in this situation, they gave extra time. So this is an hour, and you've got 2 lawyers for the judge, so they're going to split that up how they deem their half hour. So you're going to have sorry, Jay, speak 1 second. I've got an
No,
issue.
that's okay. So we got an hour. So it's they each have 30 minutes, and then it's like boom, you're done. Off to the next person. I can't imagine being an attorney and being in front of these judges. That's got to be scary as heck. Guys, thank you so much for being here to watch this. This is a major deal, and we appreciate you being here. You're not going to get better analysis on this case than Bob and Allie. So we really appreciate you guys being here. And if you could hit that like button, if you haven't already, share it out to your friends, share it out to your enemies, share it to everyone. Let them know, because you're not going to get better analysis than Bob and Allie.
See, for those of you who don't know, and I guess for those of you who do, everybody does know, but I'm not great. And I've always said, I don't really like just talking to the screen without, I need a second person. And so I am so happy that Jay was here, but I forgot how good he is at also reminding the people to do all the things that are important so that the stream and everything else is successful. So
get it in the algorithm. And by the way, they also have a merch store, and I am rocking my Team Allie Has Your Back shirt. So you see in the bottom, the Linktree Defense Stories, and I'm sure the mods will share it, but they got a lot of cool merch. Check it out. Bob is in the court, folks. If folks are asking, Bob is there, boots on the ground. So we're not going to get, like I said, we got Allie here to watch it, and then we got Bob who's in there coming out after. You're not going to get better analysis anywhere than this. So
and
thank you all so
they
much
should be very timely. They're not going to be
now that you're saying that, let me make sure I have this set up. So let me share screen. And let me go to argue. I don't want people to worry that we're going to miss this.
Do we know how to turn off the snow?
I don't know how to turn off the snow. I'm sorry. I'm not sure.
I just other people are going to be like, what the hell is going on? So I was starting to say, so you're going to hear from Richard Allen's side first. He's going to go first. He could, but he won't use all his time in the beginning, but so he'll save some time so that he gets to go at the end again. So same as you're used to seeing if you follow criminal trials, how the prosecution, who is technically what we'd call the movant, goes first and ends. It's like, oh, why do they get to go twice? So it's the person who has the burden. That's who gets to go, last if they so choose. And in this situation, Richard Allen's side has the burden. So, and I'm just going to mention, because I know we don't have a lot of time, but maybe we get lucky and they're late, that my issue has always been that once Richard Allen's lawyers tried to enter their appearance pro bono, so no longer being court appointed, that the court had absolutely zero ability to do anything. And I've also said the same thing when they were court appointed. In my mind, once they got into the middle of that relationship and he wanted his lawyers to stay, I found that there is support in the case law to say you cannot remove that lawyer. And I mention this for those of you that don't know, just because under the law, there's a bit of a difference in the way they treat court appointed lawyers and the way they treat your, lawyer of choice, your private lawyer. But I did find substantial, I want to say substantial. I found support for the fact that once a lawyer-attorney relationship develops to the point that these lawyers and his lawyer and Richard Allen had developed, that you have the same rights to keep that lawyer unless you or the lawyer want to leave. That's the, if you want your lawyer gone, or your court appointed lawyers like, I can't do this anymore, that is a different situation. And typically would be either the client doesn't like his public defender, and are we about to get some here? No?
I think so.
All right, let's just keep it in the background there, because or very, very rarely, I mean, I guess I don't know how rarely, but it's something you see less often, where the public defender is trying to get off, but it definitely does happen. Obviously, there's people who become either aggressive or inappropriate, whatever the case may be. But a judge being like, hey, I'm removing your lawyer, you didn't ask me to, your lawyer didn't ask me to, is very, very unheard of. And especially in the way that she did it. She did not give due process at all. And it's not the attorneys who we care about in this situation. It's not them like, oh, you needed to give me a chance to respond because I told you they're timely.
Ooh, fancy pants. I kind of wish they had powdered wigs, though. That would be cool.
I think they might still in other countries. I have to grab a notepad.
Can everyone hear? This is as loud as it gets for me. I hope everyone can hear this all right.
We're here this morning to argue in the case of State ex rel. Richard Allen, relator, versus Carroll Circuit Court and the Honorable Frances Gull, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus in a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley.
We're not going to waste any time.
Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Frances Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes, so you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a
Waive what
relationship.
concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or
I'm just
die with
asking you
these
to tell us
lawyers.
on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the West, if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Balden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because
Your
you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Without
those
a hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
My
Amendment
concern is getting
requires.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it. It's in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation, because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea, because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts,
And
other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, Justin. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So
Well,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance of counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent that from happening?
I think if there's a concern, say for example the pretrial publicity, the press release, if you say, listen, I think because the violation says it has to affect the fair trial. So, okay, you're going to have a hearing. The judge could have a hearing. Let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, I want to.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing Respondent, the Honorable Frances Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. and he's choosing this counsel, you have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action
They're not worried.
jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So your
Counsel,
solution,
you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County, the shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means.
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict. It was a major
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't
himself,
see Wheat as tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict. And yet the trial court found, based upon the court's intuition and judgment, based
But where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me
Wouldn't
offer
that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you
believe.
agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front end of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there. If someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So of course none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But
be
there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it
but-
could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half-measure justice. So we'll accept whatever the court's ruling is. But I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what Week is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Gull, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
Ladies and gentlemen, this courtroom will be exited in the opening match.
All right. So I had to mute myself, hoping you guys can like tell by what I'm saying. And, I wanted everybody to hear everything. To me, it's very clear that the judges have recognized that this is structural error. And, the Gonzalez case, I don't know if that was ultimately, and I guess maybe it was ultimately cited, but it's completely on point. But the issue that I've been like screaming since this happened is, why didn't they ask to be, they asked to be reappointed? Where I was starting to tell you guys before this started, I think the right to continuing counsel exists, and that there is, I started to say, substantial support for it, which there's definitely not substantial support for it, but there is support for it in the law. But when I was trying to take down the names of the justices, but that share tree link was blocking it. So it's the fourth guy. And that's what I kind of refer to him in my notes, was like, are you, or maybe it was Slaughter. Let me go back through my notes, but it doesn't matter because I'm going to go through the notes at some point anyway. Right now, I'm just giving you whatever. Are you going to ask me for different relief today? Do you want to ask for something other than what you've asked for? Because what you've asked for is for them to be court appointed again. And that was like an issue that Judge Rush, the only woman judge that's up there, well, when we go through the notes, I'll tell you which judge said what, but whatever. Like, well, yeah, you came in to be private counsel, but in your motion, it says, I'm only coming in as private counsel for like this minute. I'm not, but I'm asking you to reappoint me. And I was concerned on the first way around, when Alan went first, and they raised this issue, and they asked about waiver, and they asked a couple things that there is a huge problem that and this is a big if, if Judge Gull had been saying, I see things that are going to lead to ineffective assistance claims at trial, that is a huge ask. That would be an almost inappropriate ask of his lawyers. They would, like, if that was what I was faced with and I'm their lawyers, I'm saying no. I'm telling him no. You cannot waive ineffective assistance of counsel because there are a ton of things that could happen at trial. I mean, it's one of the biggest things that people can rely on. It's hard, so there's some grounds like that. It's definitely hard, but that's why on this rebuttal, the lawyer was like, all right, I'm going to come back to this. You asked me about this. Like, can you waive ineffective claims? And I struggled with the answer. And I struggled with it because nothing Judge Gull is pointing to leads someone to think that there's going to be an effectiveness at trial. And that kind of wish he would have fleshed it out more to say that's such a huge ask to, not in the way I'm saying, like, well, if I'm his lawyer, I wouldn't actually recommend he do that. I'd say I'll help behind the scenes. I'm gonna, you know what I mean? But if he would have sort of fleshed that out, that it's such a huge ask, and there's nothing the lawyers, although he has very well explained that there's nothing these lawyers did that rise to that level. But it does scare me. That's something that it seemed, I think at least two of the justices were kind of like, well, we could just do what you want. And he waives ineffective assistance of counsel claims for trial, because she shouldn't have to, and that's why, you know, he revisited that. But I think it's clear that they didn't want to focus at all on the, you know, jurisdictional issues, not the ones that Alan's lawyers raised the first time, because that was the wrong terminology that got them sort of off track for the first 2 minutes. But the jurisdiction of that Supreme Court to come in there instead of the appellate court, that they're saying, look, we've done it before, we'll do it again. You know, so I guess let me stop blabbering, and maybe, I don't know if you've noticed any consistent questions coming out that might be something that to answer.
Well,
You know,
before we get into that, we got over 1,700 people there. We want to just thank you so much for being here. If you could hit that like button, we'd appreciate it. Share it out. Bob, as you can tell, I'm not Bob. Bob was in the court, folks. I know there were some questions on that. Bob was boots on the ground in there. So as many notes as Allie was taking, I'm sure he was taking. I mean, Allie looked like took more notes than I took in my entire high school career. She was furiously writing. So we got a lot to go over, and Bob's going to have a lot to go over. So thank you all so much for being here.
or
I know
let me
one question.
go ahead. No, you go.
I was just gonna say one quick question I saw a couple times was, when do you think there'll be a decision, or how long does it take to
Okay.
get a decision?
So that's what I was going to get at. The judges have made very clear that they're going to make a decision fast. And she said so at the end. And they have all acknowledged that this delay is an issue. So I expect something fast. Now there is a geez, sorry, because I want to and I can't think of his last name, but Travis, he's another attorney. He's out of Texas. So I've been working on a brief, and I have a lot of time to sort of research these issues. He did a lot, and he sent me a lot, which I don't even remember all of it right now. But the most important part was they've seen quick turnarounds where the judges are like, all right, we're going to give you an answer, and then we're going to write like a whole long, lengthy opinion on this later. And I suspect that's what they're going to do here because of the issues that were raised. So, you know, Gull's lawyer is like, oh my God, if you guys do this, the doors are opening. They're coming in left and right with all the Sixth Amendment right violations that they have pre-trial. And he's trying to make a very big deal of that. The Judge Slaughter was like, hey, you know, thanks for that. And thanks for looking out for us. But we got this, you know, because what he's saying, this doesn't happen all the time. Yeah, there's plenty of little things, but we are talking about a structural error. You cannot remove someone's lawyer of choice, period. So they're definitely fixing that. It sounds like what is the struggle here is, and it was Judge Rush again. There was a couple of questions that came out where they're like, well, you're saying the record isn't clear on what to, you know, remove, you know, what the lawyers did that would allow her to remove them. You know, isn't it best that we should just do this, you know, kind of send it back and do it again? And I think that those questions represent sort of this is just an opinion now, and you know, not one who's ever argued before the Supreme Court. So, but from what I gathered from their question is that between the justices, there's probably a little bit of like different way of thinking of things. It seems that somebody's like, all right, because that's what should have happened. I mean, that's the clearest, most direct answer. It goes back. He's got his lawyers. We have the hearing that we were supposed to have. But before we do that, we've got to have some kind of hearing on the judge, though. So how do we balance that? And then at some point, there was a question from one of the judges like that. At first, I got excited thinking he's saying, well, if we just send this back, isn't she just going to do this again? What's to stop her from being like, all right, I'm going to do this same thing again. But then later on rebuttal, that was the same judge that was sort of pushing for the whole, let's go back, let's get some finality. Isn't it better for everyone else? So there's no way that they're not putting the lawyers back in. That is happening. And it's going to be either they're going to say it should go to some sort of removal hearing, or they're going to say, that, I mean, I guess it could either way, and it's going to depend on how they let them go back in. That's kind of what it's going to depend on. Are they going to say, all right, he's right. There wasn't enough to, he being on rebuttal, Alan's lawyer, there wasn't enough even to remove this lawyer, as court appointed lawyer. Or are they going to say, we're going to talk about the plainest, clearest, most direct structural error is removing your private counsel of choice, and we're going to make them go back as private counsel. So I think they're going to respond quickly. I think they're definitely putting the lawyers back. I think they might be making them go to a hearing. What would I have liked to have heard on rebuttal? And it's, I'm definitely not like saying the lawyers did anything wrong, because I'm sitting here in my head, not with them, who have all these issues in their head. They're answering the questions, you got this much time. But what I would have liked to have heard was, and I'll answer that question in a second, that them to explain that, because one of the justices mentioned it, like, well, to Gull's lawyer, well, you're saying, oh no, it might have been to the attorney general, who did a much better job at being forthright about the law and her answers. But in any event, was like, well, you're saying they could have went to hearing. They chose not to. Wasn't the writing on the wall? I mean, you're talking about a judge who said you could do it in here or we could go out there. But either way, I have made up my mind. That is a very good reason to have argued it needs to be heard in front of another judge, because this court is also struggling with, we can't set a precedent where we're just willy-nilly removing judges either. So and therein sort of lies the rub. Like, they're going to have to go to hearing on this. They're going to, I think that is what they are struggling with. So, and I don't know the timing of these questions, because you've got Jamie's that I think I might have answered already.
Okay, I got another one if you want. Jamie,
No,
by the way,
I want to clear that one up, because what time did that come? But anyway, that was, and sometimes I think I say things and everyone has just understood what I've said, but I'm interpreting it with the knowledge that I also have. So there was 2 different events where they were essentially removed. One, they were removed when they were private counsel. I'm sorry, when they were court appointed counsel, they were removed. 2, they filed their pro bono appearance, and she rejected them. What I was screaming and yelling from the rooftops, and like had Bob and find out from these appellate lawyers what the thinking was. Why didn't they assert that second act? They have not appealed that order. They have not asked the court, put me back in as private counsel, and that you have violated his right to private counsel. So therein lies, and Judge Rush did it as well, the female judge. She was like, all right, so we've got these 2 issues. You've got one, like, well, should she have removed them for this and that? But then you've got the highest one, which is private counsel being removed. That's the structural error. That one's clear as day. So there's definitely, the judges are noticing that the law is a little bit grayer when it comes to court appointed lawyers and the right to continue, the right to continuation of counsel. But it's out there, it exists, and the justices recognize that it exists. One of the judges specifically said to the attorney general, can we start with the presumption that you have a right to continuality of counsel? And she said yes. So that gives them, the justices, the ability to write in their opinion. The Judge Gull, well, I guess not, because she's technically not representing Judge Gull. She represents the state, said that they agree that we can start from the basis of a defendant has a continuing right to his lawyer, a right to continuation of his counsel. And she said yes. So that kind of, they can say, we don't need to decide that decision. The parties all agree that at least you do have a right to continuing counsel. So the question I was answering was, I think, what was it?
I can pull it up. The question
Yeah, it
was on rebut, did not understand. the
Right.
lawyer's
So
response to
that's why the judge was asking him, like, which relief is sought, because when you go into court, you have to say what relief you're looking for, what orders specifically you are raising to the court. And so, like, what I wrote in my notes and why I was screaming and like, please, is yes, he should have just said yes, fine. We will seek the relief that you'll ask for. He should have said all the things he said, because they were all very important. And what I wrote down is that after that, he should have said, but in the alternative, we will ask that you appoint them as private counsel, because that's the clearest, most direct route. They didn't do that. What I heard in his answer at the very end was, but we'll defer to whatever this court wants to do. So I don't know. I guess they can accept that as a relief that was sought. But I also think that they're the Supreme Court and they've said it there. They'll do what they want. If I can deny a writ on all the technicalities that you, Judge Gull, are raising, but then we can make a decision anyway. So she was basically saying, I'm going to decide this. Like, so give it up. That they could say, well, the Richard Allen's lawyers never asked for the right relief. They never asked for this. And the reason that the lawyers didn't, and there is a strong legal reason, is that they didn't want them to go there. They want this court to find that there wasn't enough there to even remove court-appointed counsel. And that does more protect his Sixth Amendment right at trial to raise issues about ineffectiveness on appeal and not have to be asked if he needs to waive that right. All right, now put back the other question, I guess.
Sure, I'll put it up and I'll read it from Dana W. Thank you for the $10. Would you mind explaining why the lawyers didn't want to do the hearing as a couple of the justices suggested?
Okay, so what the justice was talking about there was, he said, why are you asking us, the court, to throw this out on its face on technicalities as to our jurisdiction? Because there's a lot of the law is procedural, and what you have to do before you get to stand in this room and talk to this bench of justices. And what Gull's lawyer was saying is, hey, don't even reach the merits, meaning don't make an actual decision on the things that have been posed. Say to Richard Allen and his lawyers, you didn't do this right, get out of my courtroom. So that judge was saying, why, if she wants this, if everyone's interest is in finality, if she thinks she's done nothing wrong, why isn't she why wouldn't she want us to reach the merits? Why wouldn't she want us to put in writing whether she did something wrong? She doesn't think she did it. So it wasn't that they didn't want to go in that courtroom and argue. It's what they wanted to argue in that courtroom. And they wanted to argue, hey, judges, they don't belong here. This issue doesn't belong in front of you. Don't make a decision. Tell them, get out, go do it the right way.
I saw someone noted, one of the mods noted that there was a lot of questions about wheat, because they were referring to, I guess, the wheat case. And by the way, again, thank you all so much for being here. We appreciate it. Hit that like button, share this out. But I guess if you could clarify what that argument was regarding wheat.
So in wheat, there was a situation where the judge was able to, and it wasn't like without a hearing and all of those things, but where the judge was able to remove a lawyer. And it was like a very, very extreme set of circumstances. But even there was some, because Judge Rush, it was posed twice to the Attorney General by two different judges. They said there's not been another court where another situation, another case in all of the land where somebody has been removed sua sponte on the judge's just own, and for issues like this, and she had to answer no. And the reason I was shaking my head, like, he's bringing up wheat, like, read the room, dude. The judges have already like poo-pooed that. She literally said to him before, I'm not reading it quite like you're reading it. But in wheat, either the lawyer raised the issue, and actually don't hold me to it, but I'm pretty sure that that it was either I think that there was some sort of foundation for it, and there was a hearing, because there was another case where, if the lawyer raises it or the defendant raises it, it's a different situation. So they're done with wheat. They made very clear this isn't a wheat situation. This isn't a wheat scenario. They cited to Gonzalez like over and over again. They understand. I mean, what's good about this is it's a structural error. So even though Alan's lawyers didn't raise it right now, when you say structural error, it cannot be waived. It cannot be abandoned. It cannot, it's a structural error, and they don't. Well, I take that back. I guess it in a sense it could be waived if you actually waive it with the defendant waiving it, but then we wouldn't have this issue. So I digress. It's happening again. The trial's happening again. That's it. There's no ifs, ands, or buts. And when they say structural, they just mean we don't need to see if there was prejudice or not, because in every other situation in all of the law, almost, there's a balance of, well, fine, you've raised this is a horrible mistake that the judge made, but you know what? It's clear as hell you're guilty. I mean, the evidence is right there. It doesn't matter that this bad thing happened. No, that doesn't happen. When you have a structural error, doesn't matter. You do it all over again. So
here's
we
a
got some
question.
other questions over here.
Do
You see
think-
the ones that are, you know how to pick questions. Start with ones that are either people pay or they're members, but I will
Allie.
answer that person's question.
Allie, did you notice those were the first two that I picked? I know how you do.
Oh, you
I know
did.
how you run the show. Those are so, folks. You want Allie to put the ones back up with the ones?
No, the
that they
one you
paid?
just had. I'm going to answer.
Oh.
I will answer other ones too, but there's also ways you can see that people are members or questions. But the one you put up, I do want to answer. I'm not trying to be like that. I'm just saying I want to give those people first.
Yeah, we got them first.
Alan was given the opportunity to watch the hearing. I would doubt it. I would doubt it. I'd say absolutely not, but maybe. I mean, I guess it's possible that his lawyers could have made some arrangement, but based on what, I don't know, because all those complaints were the other prison, but with him being in a prison, I don't know if it's can you get him to this room where we can stream this thing? So I would highly doubt it.
From Michelle Brooker Ali, now that you've heard both sides, how do you think they're going to rule?
They're gonna. There's no doubt that they're putting the lawyers back in. That there's no doubt. It's just what I'm not sure of is what they're going to do with Gull, because what I would hope would be that they would decide that her mind was made up on this. It's not going to change, and that but again, they're going to struggle with how can we say the judge needs to change when the record is unclear, but at the same time, we're saying you can't remove these lawyers because the record's unclear. They're going to want a hearing. It's just whether it's going to be with Gull or another judge.
Oh, we got a $10 super sticker and a separate question from RMR. Thank you, RMR. I'm from Indiana, and I'm horrified by what is happening in this case. I think Alan is getting railroaded, and the families need justice for Abby and Libby. What can an Indiana citizen do to raise our voices?
I mean, I guess it's write your representatives and stuff and show up outside of courtrooms. But I mean, courthouses. I think the best thing that you can do as a citizen is write your local representative. I mean, that's who, if enough people call their local representative, then legislature is going to hear about it eventually. So, and I mean, also just like I said, showing up and like holding up signs and stuff. But I think there'll probably be a lot of people doing that from, I think Indiana is going to get flooded from, other places.
Does Gull have to appear in front of the Supreme Court so they can hear her side of the story?
No, essentially the lawyer that spoke for her was her. And that's why, I was like, they're not going to ask this guy to waive his being Richard Allen's, right to effective assistance of counsel at trial right here, right now, are they? So she does not, no one will appear back before this Supreme Court again. They're going to resolve this as quickly as they can. And I think that based on the questions that I heard, that they're likely going to make 2 hearings happen. It's just they'll probably say that we need to do, the first thing that we need to do is have a rehearing on, whether he should be removed, and in front of a different judge, which would, I guess, make either Judge Gull a witness. It's impossible to guess, but that's what I feel like should happen, is that their withdrawal, either her withdrawal goes first or theirs does, but their removal, I would hope, would have to be before a different judge, and then a different judge for the removal of Judge Gull. That's likely the way it's going to be. I would hope they're not going to make that. I think that they are of the mindset that that right now, and again, I wish it was just a little bit more argument there, like that Judge Gull has shown that she will dig in her heels, and putting that question in front of her to go have a hearing in front of her, not the whole trial, mind you. I'm just saying we're just going to stay on the hearing, because they're not, I think it would be a bigger ask of the court to say Judge Gull's out for the whole trial. But for the hearing on whether the court-appointed lawyer should be removed, that it should go in front of a different judge, and then we can have a hearing in front of a judge about whether Gull should be removed. And I think that goes back to the questions that the reason they were trying to push Allen to request to be appointed, not to be appointed, and to just let them file their appearance, that she must accept their appearance, because it would be a lot easier. Then they just accept their appearance and they make a motion to have the judge moved. And, now they have to struggle with, all right, fine. If they say, okay, fine, Allen's lawyer's right, and that's why they didn't ask for this relief, because they didn't want to make it easy for us. They wanted us to make the right decision. There wasn't enough in the record to even remove the court-appointed lawyers. We had to send it back so that there is a hearing, and that hearing, that portion of the hearing, not the whole trial, mind you, should be in front of a different judge, as this judge does have a conflict on whether or not she appropriately removed them before. They're clearly going to recognize that, I would hope. And then once they're back on, they can make a motion, which was already pending, to have that judge removed, which then will have to go in front of another judge. And we'll be asking one day, what is that judge going to say? That's what I suspect is going to happen.
I don't know if you saw this. Angela asked, what does Ali think about the speed trial 70-day outcome based on the arguments?
I think that they're not going to touch that. Sorry. I think they're going to say he can assert it once. If he wants to reassert it, I mean, like, the 70 days is gone now, so I don't know. But I think the point is, like, if they get back on as their lawyers, and they can file the 70-day thing there. I think that Judge Rush, I think was her name, but the female judge right from the beginning was like, all right, so you're asking us to do something on something that wasn't even done in the trial level. And now you've gone too far, procedurally speaking, as far as us like just dipping our hands in and, doing whatever we want when you've done not the right things to get you here. is what they're saying. Although the response was accurate and was correct. Well, we got it signed and ready to go for when we need to file it, which was 70 days before the trial date. So, but if she's got a follow-up question to that, because I don't remember, I don't have the petition like right in front of me to know exactly what was asked in that regard. I think it was to recognize his speedy trial right was on that date, or like to start the 70 days now, or I don't think they're gonna touch that part of it.
So I have a question. So what happens now? They all walk back behind that little door. So they get in a room and just start being like, "Well, I like that answer, but I didn't like this answer." And like, how do they go from here to make this
I
decision?
mean,
They
your
all
guess.
take off their robes. They're in basketball shorts. Like what? What
Right. So
happens?
I can tell you, like in the normal course, when we go back with judges and chambers, yeah, they take off their robe. They usually, if they're lawyers in the room, most of them tend to keep the robe on, but they're also about to go right back out. But I've never met a judge in chambers in their robe, like when they weren't going to go back out. So, but I honestly, I don't know. And maybe there's someone out there that does, but I would assume that, yeah, they powwow, but I don't know if it's something like, because in the Supreme Court, it's probably more like you've got your, like your head judge, the chief judge that's going to write for an opinion. And then I think that what they do is they have, they have like some discussion about it, right? And then they kind of come up with like who's all on whatever sides, and then one writes the opinion. Okay, this is the opinion of all of us who think this should happen. Then the other guys, they do a new powwow, and they draft that what their either concurrence, or if they don't agree at all, they draft a whole separate part of the opinion, and it sort of gets at the bottom of the case. And it's like, well, these are the judges who didn't agree with what happened. So, and it sounded like you could hear the judge has already done some research. They already determined, all right, there's been other times where we've reached, because again, like I started to say at the beginning, there were some technical, things that they should have done that they didn't do. And the appellate track was, in theory, a possibility that they've decided that those are issues that we've done what we want before. We'll do what we want again. And we're not worried about the water, gates opening and us getting flooded. So I think they probably already have a fairly good idea. And it sounded to me, based on the questions, that the struggles that they are facing is exactly kind of what we've been talking about. Are we saying that they shouldn't have been removed and we're putting them back as court appointed? Are we saying that you've asked us to reach an error? We're finding it's only structural if you're on as private counsel, and they're saying, I don't think I don't think the court's going to say, we think there was enough there for her to remove them. They seemed to feel very strongly that it wasn't, that wasn't the case. So sorry, I got distracted because then I started to look at that question and
I'm sorry. That's my fault. I'll pull it up while you're talking. Because we got Miss Cat here who says, was sent $10. Thank you. First, thank you so much. Second, I'm a new Patreon member. Excellent.
Hey,
thank you.
thanks.
Check it out in the link tree, folks. If you want some exclusive stuff, make sure you sign up for Patreon regarding YouTube. The podcast, make sure you're signed up. Question: did you get a feel as to how many of the judges are leaning towards putting attorneys back on the case?
All of them.
All of them.
All of them. It's just the matter of how. It's just a matter of, what's the process and how we're going to do it. Like, do we need to go back and then do a hearing? That's what kind of I was saying, like, do a hearing, and do we need to do it in front of Gull? She's already decided. There is no doubt, no question, again, that it is structural error. Now, I think if they're back there talking, they have all identified that there was no real, reason, but they're trying to soft pedal it. Like, well, the record's not fleshed out yet, but on the record we have, there's some issues, but nothing that allowed the judge to do what she did. So they're definitely all, handling that aspect of it. It's just kind of a matter of how, because to make them do the the hearings, and to do all of that, it's going to take, a lot more time. But as far as one hearing on them being removed, then one hearing on the judge being removed, it didn't sound to me like anyone was planned to say. I mean, there was definitely at least one judge who was like, all right, well, let me hear why the appellate track is not a viable option. But it seemed there were too many on the other side of that. Meaning, I'm sorry, I should flesh it out, that one of the things Judge Gull said, and a jurisdictional bar to presenting an original action there in front of the Supreme Court is, did you have another avenue? And the other avenue is an interlocutory appeal to the appellate court. And that, that was a fear, like, oh, man, that's an actual issue. Like, I honestly did think they technically, they could have gone to the appellate court, but I got the general sense from, it's probably that none of them are going to say, I'd be surprised if they were like, yes, you should have went to the appellate court. Bye. I think they're gonna make a decision, and based on that, as opposed to a technical thing, based on the merits of the case, I felt every one of them thought what she did was wrong. And I would venture to guess the struggle is, we don't want to just like we don't want to open a, say that judges can remove clients, the lawyers from their defendants like this. We also don't want to say on a record we don't have enough of, that Judge Gull cannot be the judge on this case. And I'm suspecting that's what they're struggling the most with. That's why I think it'll be first that first hearing about whether, and then that's the other thing I think they're struggling with. Like, do we even need to send it back and play the game like there should be a hearing to whether these guys should be removed, when we can all tell on this record they can't be removed, because if they're removed again, it's still structural fucking error. I didn't say the F soft enough, but maybe the AI that,
You're good. I curse all
in
the
there
time.
won't-
And we have no. You're good. I saw a few. Do you know what is Bob planning on? Like, what's his plan? Is he coming? Like, when is he gonna come on? I did say I could bring him on if he wanted to, or is he coming on tonight to talk about it? Go over all his notes. Do you know what he's planning on doing?
I know that he's having lunch with some other lawyers, and we didn't really talk.
Don't worry,
about
guys.
it.
Just make sure you have notifications on, and follow on Twitter too. We will let you know. I'm sure Bob is itching to go and talk about this, so don't worry.
I'm sure he is. I can guarantee you that. So most of the people are bored of my, like, hey, where's Bob? When are we going to hear
No,
from
they're
him?
not. They are not at all. I just saw someone said they love your analysis and they're loving this. So no, not at all. Joanne, who has been a member for 3 months, thank you. And Joanne's awesome. We love Joanne. Did the justices have their Wheaties? A lot of wheat. A lot of talk about the wheat in that
There
hearing.
definitely was, and it's because it's the one case that they can that like can even be argued that what the judge, that the judge had the right to do what she did. And that again goes back to some of the other questions we had about, like, why did the judge ask Gull's lawyer, well, why doesn't she want us to even make a decision? She thinks she didn't do anything wrong. Why don't you let us say it? But it seemed to me that they all recognize that doing it on another track, as it should have been done, probably, it's too long. It's too much more harm is going to follow. And, but maybe they're talking about, well, we do things like that, because there are long delays after convictions where, people are fighting, innocent people who've been wrongly convicted, fighting forever. When you're talking about these long delays pre-trial, he's in custody, for God's sakes. Like, I don't know why they didn't ask for bail, but I mean, I guess that'd be absurd to ask to the Supreme Court at this point. But, they're gonna recognize that, even though I don't know if it was raised, maybe it was in the briefs, but that he is confined, he has lost his liberty. Every delay even to go the appellate route is, you know, that's why that it's wholly not available to us, because it's impairs every other constitutional right he has to a speedy trial, you know, to, you know, not be detained pre-trial forever. So
Just so you know that when you said that people are bored, the comments were flooding in, not bored, that they're loving it. All Team Alley comments.
I was teasing. I was teasing. I know you're not. How could you?
Carol, does it have to be unanimous, or does the chief judge have the ultimate decision?
I think that it has to be like a certain number of them have to agree. It definitely doesn't have to be unanimous. It's rare when something is unanimous. That's like the strongest law in the land. It's like, oh my God, you had all the judges and they all have said the same exact thing. But I suspect you'll have all of them agreeing on issues, and then kind of the who, the how, the what, like the other questions that will be where the differences lie.
We just got Persephone Applewood says, I can only imagine how hard Bob had to bite his tongue while sitting there. And
I'm sure
$5,
he's
thank you.
That's why I'm saying, like, he went to go talk to other lawyers. Like, he's out there, you know, because I didn't even get that call. I mean, plus he knows I'm on with you guys, but and I still have all my stuff blocked. Oh,
How long is that drive for him?
3 hours, I think, or 4.
That's how much he loves you guys. He's driving out there to be boots on the ground so he can come on here later and give you his
Might be even
analysis.
more than that. Yep. Yeah, and that's why I'll just save all my notes to go through some of it with Bob. But I definitely, you know, got the sense that they're gonna. I don't know. Are there people out there that are still wondering, like, maybe they're not going to do anything, or that the lawyers shouldn't be, you know, be put back on? Because I think everyone's of the mindset that that's what's going to happen. But I don't know. Bob knows more about what's kind of the feel is in the world. But I know he has told the world. So
Well, we could do this right now. We got some new members. Kristen, thank you. Jen, Catch List, Raul, thank you so much. What else we got here? We got $5 from Radar. Buying you your morning Java, Ali. I bet your head's spinning. Can't wait to hear you. What else we got? Legal Mom and Jen. We love Jen. Love when Bob, Ali, Jay, Defense Diary Peeps, and J-Bo Nation collab. We love it too.
we do. And if you guys don't, you know, anyone who didn't already know Jay, and I know we have a ton of crossover, you know, people, but that there's really interesting court coverage, and I've never been bored on with you.
Oh, you're too kind. Thank you. We got Jews of All Trade who gifted 5 membership. Thank you, Jews of All Trade.
And I meant when I'm literally with you, like you're always keep it interesting on, you know, but when I'm watching, it's always amazing. But I mean, like, it's always fun for me when we're together doing it.
Yes, absolutely. We got to do another double date. We haven't done that. It's been too long.
Yeah.
Maybe we do a double date, and me and Shannon try to convince you guys that Wendy Adelson is going to get convicted. Oh, 10 memberships just gifted out by Shiraz. Thank you so much. New member Jen.
All right, let's just see what I'm trying to scroll down the most recent comments and just, you know, see if there's any.
Let's see.
Well, everybody still finds it's, you know, finds it interesting. I mean, I'm going to look at my notes while we do this just to see, like, because I know there were some things like I stuck like stars and I'm like, oh my God, seriously?
Let's see what this one is.
Okay, so the one of the things, like, the woman judge, of course, I'm going to forget her name again. She's like, you know, you're not really, like, when Richard Allen's lawyers kind of first started out, she's like, you're not really citing any case law here. And, you know, why are you throwing jurisdiction in? Like, what are you talking about? Because there's a way it used to sort of be used to say, like, well, the judge is outside of her jurisdiction when she makes a rule, an order or ruling that she can't. And there's been case law that sort of clears all that up. It's like, no, if the judge is sitting in the right courtroom, hearing the right kind of cases, it's not a jurisdictional question. It's a authority question. Like, so she just, sort of was trying to kind of get him to argue sort of like the right ways. And then when they started talking about like findings being correct as far as Judge Gull's, findings, like that they had these, to remove the lawyers in the first place, the judge intervenes and like it's Strickland. So that was the judge with the glasses. And he's like, well, if she was right, and there's going to be a Strickland problem later, and that's the case law that dictates about the rule for ineffective assistance of counsel, what if she's right? What if she is right? Is he waiving all of the things? And we kind of touched on that before. That was like out of the door. Question number one. So that's sort of what I started to say scares me about the possibility that they might resort to saying, and it might, like the whole, you didn't ask for the relief from private counsel. You asked for the relief as continuing counsel. So what if we make you, as a result, waive all of your right to effective assistance of trial counsel? And I honestly hope the other judges will fight back on that because of the argument that he made. Like, this doesn't rise to the level of, because it's, as soon as you give in one of these proceedings, when I say give, like the judge is like, but you'd have to agree this, right? You would, and you say, yes, that's it. They're part of their opinion, and they get to avoid all the legal ramifications of deciding, because they just get to say during argument, counsel agreed that, conceded this issue. So there's that, so that's why I think there was like all of that pushback. And then the next question was about why their jurisdiction. And I don't know if it went there because he started talking about jurisdiction, or if it was like really what the justice has had on their mind. Like, why isn't our appellate process available or insufficient? And then I wrote, wow. So let's see.
By the way, this is pretty cool. I can show, let me see if I could share. I could show each judge so we could take a look at who they were. So there was, I think the chief here is Loretta Rush. And by the way, I can give you a little moment. You ever have a moment? Oh, am I muted? No, I'm not. Okay. You ever have a moment where you realize you're really dumb? I was. Oh, why is this not on this? Is this not changing from? Hold on. Let me see something here. I had a moment this morning. Here we go. Where I looked at this. I had a moment, Allie, where this is how dumb I am. I said, "Oh, look. They all have J as a first name." I had that moment, Allie. It's a moment I take back, and I'm like, oh my God, I'm that dumb. And then I was like, oh, it's the judge. But anyway, so all right. So we had Judge Loretta Rush, who I believe is head. Then we had here we have oh no, it's not. It doesn't switch. All right, so let's share this tab instead. We have Judge Masser. And
Right.
then,
and I'll probably call him Massa because that's what I wrote in my notes. So
I think wait, that's weird. It says on here. Yeah, oh no, it's Massa, just Massa. You're right. All right, so then we have. Let's go to this one. Share this tab instead. We have Judge Slaughter. This guy seemed angry. This guy seemed the most angry out of all of them, from what I noticed. And then
he got angry, and when he really got angry was when he was like, I'm just trying to help you. When he, being the lawyer for Gull, tried to tell them, if you do this, watch out for the precedent you're setting. Everyone's going to come running to you. And then I do have another note where but I don't know that I had his name. I might have been calling him third judge. Let's see, because
So
I
we got
couldn't see because of the link.
Judge
Um,
Goff, and then the last one, I'll go back to us. The last one is Judge Multer. Judge Multer. All right, so let me.
All right, but
Yeah,
before I
guys.
do this, by looking through my notes, I started to get exciting because I was like, oh, wait, why did I put this star here? And then I wrote, why did I write wow? So we all heard it. We all heard it here. The defense wanted to catch the state on their back foot. They were ready to come at them like, boom, we've got this case. You're not going to be able to fight it. And you know, there's an acknowledgement of like he was already harmed by this. You know, that type of harm when it gets to an appellate court there would be that balance that you don't have in a structural error case. But he's like, this was our plan. We were going to get them on, you know, catch them not ready, you know, to address it and not ready to do it. And it would have been, you know, it would have been pretty good. But if in all honesty, if they wanted to catch them not paying attention, why the hell did they spell it all out in their motion, in their long memo? I mean, that's the number one thing that like defense attorneys don't want to do. That's why we don't want to talk to the press. That's why we don't, because we are secreting whatever we can away. So we've got something in our arsenal at trial that they're not expecting us to say. So saying it all in a memo like that, just spilling your beans, you know, but I guess they thought we've got 70 days and that's not long enough for them to kind of front all of this. But, you know, it was what they were saying out there.
Someone just asked. I don't know if you know the answer. Jenna asked, you probably answered this, but the guy that went second to last was the Attorney General of Indiana. Is that right?
Yep, that is right. And she, you know, her primary push, she recognized that it's structural error, you know, and that I think I read the Attorney General's response. I remember Bob and I talking about it. I'm like, they had to say that because it's right. Like everyone knows this is happening again. So you've got to make it right. It's just, do we make it right? We being that panel of judges, do we send them somewhere else to make it right when we know it needs to get made right? And, you know, we can write very strong language in our order, in our opinion, that says, don't anyone else think they're coming at us, but we've got the right on our own to do what we want, and we're going to. In this extreme, unusual case kind of scenario. And you know, that's what I expect that they'll do. And that's why Judge Slaughter was like, all right, yeah, you know, we can handle our own over here. You don't need to do that. But then one of the judges, go ahead.
No, Legal Mama Jan, thank you. She says the Attorney General is Todd Rokita, and that was Angela is a Deputy Attorney General. Thank you, Jan.
So then like the fourth question that they asked was, if they had agreed, they being the lawyers, to go to a hearing, wouldn't we have a record? And sometimes they ask those questions as like a what do they call that? A golf ball or a like softball. See, that's the other thing that Bob's always good to answer to finish my sentence when I do stuff like that. But throw them a softball, like, and sometimes it's a real issue. And so on that, it seemed like, you know, they could have been waiting for them to say no, that she wouldn't even give us the transcript, which is basically, you know, what they said. And also that we don't know, because the other answer was we don't know because it didn't happen. And then that's when Judge Rush, so the chief judge, she chimes in and she says, okay, because his response was, well, there wasn't enough record for me to, because remember if I said like the first issue that one of them raised was, and it was right before we got into this line of questioning, couldn't you have gone to the appellate court? And that's a legitimate concern that I noted in here, like in my mind when I looked at it, that's actually could be considered like a bar, a jurisdictional bar to walking into the Supreme Court. But again, based on where we ended up, it's clear that they have decided we're hearing it, regardless. So the next follow-up answer, part of the Richard Allen's lawyer's response to that was, well, there wasn't even a record for that. She wouldn't even give us the transcripts. And how are we going to rush into the appellate court? Hey,
Who's
Oh,
there?
what's up?
There he
we
is.
got to figure out how to rearrange it so you're not jammed at the bottom there.
Is it, no, I'm good. Is it, I had a hard time finding a signal. I'm out
There
to
you
eat
go.
lunch.
Look at
So how's
you,
it
so
going, y'all?
handsome and striking over there. Hi, Dave.
Oh, geez, thanks.
Mhm.
So did you guys enjoy that?
I mean, it's crazy. We're still talking about it.
Yeah, it was
We
nice.
definitely want
It
to hear
was-
what you. I was surprised you weren't like ready right away. Like I know you probably had other
Well,
lawyers and people to talk to about. So
yeah, I had people to talk to. We're out eating lunch now, but it was, I thought it was interesting. I'll tell you flat out. So they didn't bring up Gull, removing Gull at all, as you guys know. Not even meant, it wasn't even mentioned. I think that they didn't focus on the procedural side of it. I think that they got to the substantive issues, which is good if
right.
you're pro getting these guys back on. What my gut's telling me is they're going to reinstate them. They're not going to remove Gull, and they're going to kick it down for a hearing. But remember, Brad and Andy filed a motion for her to be removed for
Yep.
recusal.
And
So that's
that's what
still out there.
Yeah, that's sort of like what we discussed. And I was actually just going to read the note I was getting to that was the chief judge's question right after the judge asked about, well, because there was some questions about the appellate court, but we've sort of fleshed out here that it was clear they're answering it, they're putting the lawyers on, all of that. But her response when part of their answer was, well, the record's insufficient and she wouldn't even give us the transcript, that she said, well, there's not enough here to say, you're trying to tell me there's not enough here to say the lawyers should be removed. But on the same record that there is enough to tell us to boot the judge. So I was saying that I agreed that like they're not going to want to remove the judge for this. But what I'm
Right.
hoping, what I think that they could do is say, you're going to go back as court appointed lawyers and we're going to have the hearing, but that hearing will be in front of a different judge. And then you can proceed, like you just said, on the motion that you filed, also in front of
Right.
another judge to recuse.
Yeah, right. Neither of those motions can be in front of Gull. Like obviously
Right.
the removal of those guys cannot be in front of Gull. That's the only way to avoid, just the obvious bias that I think that she has. And, the public's trust in the system, that's the bigger question. I thought it went really well. I thought Mark did a great job. I really did. And he was nervous going in, but I thought he was great. I thought that Gull's attorney was good as well.
Horrible.
I mean,
I thought he
mean,
kept focusing on wheat when the chief
right.
judge
He was a one trick pony, no question
and the
about
chief
that.
judge said early on, I'm not reading it quite as clear. And then at some point later, when he just keeps weeding the hell out of her, she's like, can you please give me some other authority outside of wheat?
Right. I loved the chief judge.
Yeah.
Now, could you guys see that she had a little Band-Aid on her nose on TV or no? Oh,
Well,
good.
not me. I bet
I was great. Like she was like flanked by old white dudes. Well, kind of old white dudes, but I love that she's the chief judge. So I was a big fan of hers. I thought she asked the most pointed questions. I think she was very, very much in line with Gonzalez in terms
Yeah,
of
from
like,
the
look,
start.
if we don't put these guys on structural error, I mean, she said that flat out.
Yeah.
So I anticipate that they're going to get back on, which is exciting
What were you
for
thinking
Rick.
when the judge said to them, "Do you want to ask for this alternative relief right now? Like, you didn't ask us to put you on. You want to ask right now because that one's structural error for sure," which is what the chief judge had said a moment before.
Are you talking about that they had entered their pro bono appearances, that they were, is that
Right.
what you're
And
talking
you
about?
didn't
Yeah,
ask me to put you on as private. You've only asked me to reappoint you.
right, exactly. Yeah, in the alternative, well, you and I had like, we're very, very much, you look very beautiful, by the way.
Oh.
And Shannon, if you're out there listening, happy birthday.
She is.
Oh, I think
Sorry.
you mentioned it earlier when my mind was still racing. Happy birthday. Happy birthday to
Birthday
you.
to you.
Happy
Happy
birthday
birthday
to you.
to you. Happy
Happy
birthday.
birthday.
We'd be full throat if we were like private, not in front of 1,300 people. So
Yes, yes.
we love you, Shannon. Happy birthday. We're sorry we stole Jay. He probably took this entire day off to spend it with you, and him being the generous soul he is. And my brother jumped
Of
in
course.
to lend a hand. And we appreciate you, Jay, so much. And Shannon, we love you. Happy birthday. So yeah, it was great. And the trappings of the court, it was just such a, there's not much that's like an argument like that when you're in there. And I kept telling everybody, all of our community that watches trials, that's a very different experience. It's like I was trying to warn people. I'm like, look, these judges are going to interrupt these lawyers in mid-sentence constantly, and then they're not being rude. That's just how oral argument is. I mean, they came in knowing the issues that they wanted addressed from the lawyers, knowing what the holes in the arguments were in terms of the briefs, and that's what they do, and they address it. And I thought Mark did a great job, and
Can I
he's
ask you something? Are
sure.
you concerned with the possibility that they might actually suggest that, yes, we'll put you back as you ask and demand, and we'll do all the things you say, but we want Richard Allen to waive his right to effective, which I'm not active, can they? But to waive any rights on appeal to
I don't
ineffective.
think they. I don't think they'll do it. But I think it's limited only to those issues. You know what I mean? Like
But
I
that's not
don't
what
think
they
it's.
were asking. They
Yeah, but I
asked.
don't think. I don't think the law supports that. I don't
I
think it
don't
can be
either.
a blanket waiver. I think it's going to
Right.
be
I
limited to
agree.
the issues. So, and I don't think they're gonna want to address that at all. They're gonna leave that to another court. But, to me, the bigger issue, and I was glad it got addressed, and I thought it was addressed in terms of, the procedural bar, in that they didn't, follow typical protocol to get up there. And, I thought Mark did a nice job with it with respect to, look, going through the process, having Rick Allen get convicted and going through the regular appeals process is not a remedy. You've got to handle it on the front end here. Everybody who's in the law game knows that once somebody's convicted, getting them out on appeal and getting a retrial is like Herculean task. It's so hard to do. That is not
But
a remedy. That
they
wasn't.
were also asking about an interlocutory appeal. Why didn't he do an interlocutory appeal?
Yeah, but like the one thing that Mark didn't argue is that you've got, and we cannot pretend that Librado and Scrumman don't want this case. This is like a kingmaker type case, especially if Rick Allen's actually innocent. Like, this is a career maker. Like, if they get handed a case where, based on my conversations with certain people, they're confident that Rick Allen is not the guy, and you're handed that case on a platter, man, I mean, what, like, that in and of itself is going to predicate that they're not going to be very proactive in terms of filing anything on behalf of old counsel. Like, we don't want to give these guys this fucking case back. No way. You know what I mean? So, like, for me, that wasn't a real option. Like, even assuming, because you have to ask for Gull's permission to file the interlocutory, which I assume she would have. Like, I mean, like, what justification was she going to have to not
I
give
mean,
her approval? But she could.
she's done a lot of really outlandish shit.
There's no question. There's no question. Yeah. So I don't know. It's my gut says they're getting back on. I don't think they're going to remove Gull, and I agree with you. Your assessment's spot on. I think they're going to have different judges. The problem with with Carroll County is very small, and Diener has recused himself from the matter. Now, does that mean that he wouldn't be able to sit on the recuse? Like, I don't want them bringing in another Allen County judge to hear either of those. That's not equitable. Like her county, we can't have a
No,
judge in
no,
her
they,
county.
if they're going to
But
do that,
where do you pull a judge? Like, where do you get a judge from? Because like Carroll County's that small. You know what I'm saying?
yeah, and it's not like a
So
situation. We had a situation where they had to put like a private lawyer, private lawyer in as the prosecutor in Chicago, like on a case that involved police, and I think they ended up putting like a defense attorney that prosecuted it, kind of thing. But you can't put a non-judge on as a judge. So
right.
yeah, that'll be interesting.
Bob,
Yeah.
we got a $5 holla here from Miss Cat saying, Allie looks beautiful.
$5 holla, Miss Cat.
And-
Thank you.
And Bob looks
Isn't she
very handsome.
gorgeous?
So not only is it a $5 holla, but saying you're handsome, Bob. Look at that.
Oh, I mean, that's worth everything. And I mean, Allison, of course, is very, very beautiful. Did you get any sleep? Like y'all know, I told y'all, it's like Allie has been working like a dog to get that post-conviction relief like for 2 weeks, like no sleep. So like you look amazing at all times. And I'm sure, was she brilliant all day? I'm sure
All
she was.
day. Brilliant
That
all
was
day, Bob.
that was like
Well, we stayed muted so everybody could hear the stuff. I just took diligent notes, and like there's still a bunch of people here, so I was going to go through them. I mean, we've talked a lot about the things like that stood out right from the jump, and but yeah, thankfully Joe's here because I don't like talking to his screen.
Dude, the guy's a hero. Like seriously, I was so concerned, and then when Jay offered to do it, because I knew he wasn't streaming on Thursday, and then when he's like, "Dude, I'll jump on," I was like, "Oh my god, thank you!" It's like huge because Allison was so nervous about
I mean, not
everyone complains about me talking all the time, but people don't understand that's how she wants it. Like I'm the
That's
yapper.
not true. That's not true. Don't try to give yourself an out right there.
Oh shit! Why
You
throw
and
me out
Jay
under the
both
bus?
do very good at like talking to the people. I need like a person there.
We're the men of the people. Like, that's what we are.
Love
We
the
are
people.
men of the people. All right. I love y'all.
Oh, Bob,
I'm
Bob,
gonna
before you
eat.
go,
Yeah.
tell what's your plan? Like people want to know, like, are you coming on later? Like, what's your deal tonight?
Are we going to do a live together?
So we're doing our live, the long-awaited live with the prosecutors pod but it's Patreon only. So if y'all aren't patrons and you
It'll get
want to
released,
see
though.
that, and it'll be released. But we are very much on opposite sides of that.
Wait, are we talking about this case or the?
Yep.
What?
Well, I don't know that we'll get into the facts, but we're going to talk about what happened today. But how do you not bleed into the other stuff? You know what I mean?
Right.
But yeah, I mean it should be fun.
Well,
That's
he and
it.
I are also on opposite sides of, is there a continuing, do you have right to continuance of counsel, which the chief judge made the attorney general, at least, unless it was, I got to look back at my notes, unless it was the other Slaughter, like,
I think it was Slaughter that brought up the continuity. Yeah.
and said, you're going to agree to that right here. And she's like, yes, we can agree that you have, that we're going to start with the presumption that you have it.
Right. For sure. So yeah, that's at 8:30 tonight. And I'm kind of homeless for like the next bit here, but I'm supposed to jump on News Nation and do like a pre-recorded thing for this at like 5:45. That's why I was telling you, babe, like I got to figure out.
Oh, that you're
what
hanging
I'm gonna
around.
do. Yeah. And I got to figure, like, I think I could probably go to somebody's office and do that. But if y'all are hanging for a while after I eat, I might jump back on.
And then
If you guys
I'll
are
jump
hanging.
off because I've got a sentencing hearing in an hour 15.
Well, guys,
Okay.
make sure you have notifications on. So whenever Bob and Allie go live, you get the notification. Follow on Twitter and a Patreon. Be on there. You guys there's so much exclusive stuff you can get on there. And I'm sure the mods will share it here, but make sure you're signed up for the Patreon too.
So
And
wait,
someone's
Radar
sticking
was
the
asking
chat.
a question about whether or not I heard any chatter. I mean, like, I did, but it's all opinions, you know. I mean, everybody's kind of walking around speculating on what they think's going to happen. I mean, I'm obviously a defense bar guy, so you know, I mean, it's pretty evident where I'm at on this thing, and you know, so that's who I'm talking to. I certainly wasn't talking to anybody from the state. So, but we all pretty much agree. I mean, I came out of it feeling, as did everybody else, you know, on the defense side of it, you know, Mark and Kara and Brad and Andy all feel like they're going to get back on. Like that's, you know, but those guys, because they're under the gag, make any kind of statements, but we all felt pretty good about it. I just gave Mark a nice toast at lunch here because he did a hell of a job. So I was proud of him because look, this is a day for the defense bar. You know, this is a day for the Constitution. This is a day for the Sixth Amendment. And like, that's what it's about, you know, and people lose sight of that. This isn't like it's so much less about really Brad and Andy, and it's really all about Rick Allen. And you know, it's so important. And whether you think he's guilty or not, or innocent, we need a fair trial, and it has to be. We cannot have judges picking who our lawyers are, because imagine, God forbid, and I'm talking to you guys out there, somebody in your family's arrested for some shit that they didn't do. They get appointed a public defender who works their ass off for a year, and you form a relationship and you trust that person, and you've got some judge who doesn't like them and doesn't like the way that they're handling the case, and then just removes the person who's like, your literal life is in their hands. Just try to put yourself in that person's shoes, that person being Rick Allen, and maybe you'll have an understanding of what's going on here and why it's critical. It goes way beyond just Rick Allen.
Babe, the people want to know who was there. Family of Rick's, like what?
No, Kathy got stiffed out of, like, she was going to come, but she wanted her support system, and she could only get one seat, so she didn't come. Victims' families were there. Gull was not there. Gull did not show. In terms of Doug Carter was there, Indiana State Police. And then, you know, the usual suspects from like the Delphi community, you know, Kevin and Anya, who didn't even say hi to me.
Wow.
Like, I don't get that, dude. It's like whatever their deal is, it's, you know, I'm just not going to get involved with it. I don't know what their problem is with me, but I find it unsettling and undeserved, more importantly. But so, yeah. And then just, you know, the typical folks. But in terms of, you know, Brad and Andy were obviously there. But in terms of the players, Rick was not there, obviously. So, yeah, I mean, that's basically the long and the short of it. All right, let me go eat. I'll jump back
For
on.
me, I'm starving.
I will. All right.
All right, take care, Bobo.
Love you guys
Love
out
you,
there.
babe.
Love you,
Thanks for
Bob.
watching. Make sure you're subbing. Jay and I are like in a heated race. We're both like 11K subs. It's like two thoroughbred horses.
Somebody tell me
it's
how
a
many
great
likes
race.
we have, because we've had a lot of people. I don't know if anyone likes until the end. And
yeah, people got to like.
Can I make one request, folks? It is my amazing wife's birthday, Shannon, and she has her own channel. I'm going to put it in the chat now. I promise if you like our channels, you will like her. She's Mindful Crime Couture. It's her birthday. If you could give her a subscribe, I just put it in there at Mindful Crime Couture. If you could give her a follow, it means
I'm assuming I'm already.
And Shannon is doing
I will
something that
double-check.
no one else is doing. Like she's coming with some like original creative stuff in terms of, I love that channel. Y'all should definitely be subbing because it's family. Like, if you, like Jay said, if you love us, you're going to love her, and she's amazing. And she's just, it's just a great concept. I love the concept. I was calling for her yesterday when we were, I was like, where's Shan's when that, you know, the witness on, you know, Troconis was up there.
You
I
said
was like, we need Shannon like evaluating her whole look, you know. And it's
948 likes, so we're almost at 1,000. If you haven't hit that like button, let's get this stream to 1,000 likes. We appreciate you guys so much. So
and I'm about to go back into all what the judges were saying and what it means legally. So don't leave now.
Yeah.
All right. I love y'all.
All right. Love you. Take care, Bob.
All right. Bye.